Welcome, everybody. If you are looking for a different event, this is the Future of Federal Faith-Based Initiatives. I'm on behalf of the Christian Legal Society. I'm John Christman. This is Matt McGee. We'd like to also thank our primary co-sponsors of the Federalist Society and the program in public law who have helped make our speakers' attendance at this event possible. We'd also like to thank other student co-sponsoring groups, the Duke Law Democrats and the Duke ACLU. I'm going to be very brief and very short, and the title of this event is the introduction that you know. It's about the faith-based initiatives, the creation of the office, the history and background leading to it, and then the competing perspectives on the office itself. There's been a lot of debate about the office since it was first created by President Bush. President Obama has spoken about wanting to continue the office and perhaps even expand the office's purposes. But he's also intimated that maybe he's going to make some changes, and we wonder about what those changes may mean constitutionally and practically. Professor Esbeck is going to start the discussion off by beginning with some historical background leading up to the creation of the office and then what the office was itself, and then he himself is going to share his views about the office, and then Professor Anders is going to, not Professor Anders, Chris Anders is going to go after him. Chris Anders will then speak for about 20 minutes, and then after that, if they feel the need to respond to one another, they can, but otherwise we'll just open up the floor to questions from the audience. So without further ado, Matt's going to introduce the two speakers.
Carl Esbeck is the Isabel Wade and Paul C. Litta Professor of Law and the R.B. Price Distinguished Professor at the University of Missouri School of Law, where he teaches in the area of federal civil rights, constitutional law, religious liberty, and civil procedure. He has numerous scholarly research and publications in the area of religious liberty and church-state issues. He was formerly senior counsel to the Deputy Attorney General at the U.S. Department of Justice, as well as the director of the Department of Justice's Task Force on Faith-Based and Community Initiatives. He's also served as the director of the Center for Law and Religious Freedom, and he's widely recognized for his role in drafting the charitable choice that was part of the 1996 Federal Welfare Reform Act. And Chris Anders is senior legislative counsel at the ACLU in Washington, D.C., where he represents the ACLU before Congress and the executive branch. He's been with the ACLU team since 1997 and has represented them on a wide range of civil liberties and civil rights issues. At the beginning of the Bush administration, he lobbied Congress against legislation that would have codified some of the Bush faith-based initiative, and as a result, the initiative was not codified. And finally, Mr. Anders has also raised some concerns about the Obama administration's reformulation of the initiative, which he will share with us. And so we'll hear first from Professor Esbeck, but please join me now in welcoming both guests.
Thanks for being here. And we're not at all insulted if it was the burritos that brought you here. And while Chris and I have been on the opposite side of this particular issue, we've worked together on something called ARLUPA, an acronym for the Religious Land Use and Institutionalized Persons Act, which ultimately made its way to the U.S. Supreme Court and was sustained its constitutionality, at least in part, to the extent that it was challenged under the Establishment Clause by a 9-0 vote. So we did something right there, Chris, and we did that together. When I sent Jonathan my title, the sort of a subtitle was Promise or More Problems. And that alliteration was maybe a too cute way of trying to raise an issue that I know my students would have on their mind, and I suspect you do too. And that is, well, what's this all to me, and why should I care? And I want to give two responses to that. There's a primary reason why you should care, and something ancillary to that. First, The primary reason is we want to get this right because it is about the poor and the needy. And by the needy, we of course mean those who have chemical addictions and need rehabilitation, prisoners who are about to be released from penitentiary back into their communities. They're without job skills and quite likely to fall back unless they have a support community back into the same crowd that got them into the penitentiary in the first place, or someone caught in domestic violence and trying to protect herself and also to protect her children. And those are the kind of needy people and increasingly people in need of credit counseling because they've overextended themselves. So we want to get this right. That's the primary reason. A secondary reason is this, and this is not original with me, but it has to do with civil society. And this has something more personal to those in this room who are middle and upper middle class. And if you're not there yet, you will be because you're about to be lawyers. And while in many respects our society is multicultural, in many respects it's not. It's monocultural. Along the continuum of income and assets, many people in the middle and upper middle class simply don't have any meaningful contact with the poor. And America is unusual in that the government, by and large, doesn't do social services itself, but rather hands out grants to do social services through the private sector providers. And private sector providers, of course, work with volunteers and full-time employees. But it's an opportunity which is widely availed of for the middle class and the upper middle class to come into positive relationships with the poor and the needy. And that sort of positive interaction builds empathy. And it's not too much of a strain at all to say that when you do social services through these private sector agencies, you actually come away with as much benefit as the people that you went there to help. I just give 3 hours a month to legal aid for free. That's not much. But when I see and put a face and a name to these people, then I can better understand, and then the lawmaking class from which we're drawn, who can shape policy, can do something about their situation, if nothing else, to better empathize and understand that these problems are real, even though we shouldn't over-romanticize it. Sometimes they're there because they've made bad choices. But who among us hasn't made bad choices? And we'd like a second chance, and so would they. All right, well, I'm going to take you back to a real quick historical overview, because context matters. And I want to start with the early 90s. There were a number of social service or social science studies done, and they were looking at the private sector groups, mostly non-religious, but a few religious, who were doing social services, and they did not like what they were finding, in that they found that the interaction with the government was destroying their innovative spirit, their entrepreneurial drive. They were getting tied up in regulations, micromanaging what they were doing, and the government was quite unintentionally just creating sameness, and we didn't want sameness. We wanted different ways of addressing the same kind of problem so that we had sort of a parallel market mechanism there to see what the best way was to address particular problems. And the best way might be different in Nevada than it is in Florida. And all that was getting seriously damaged. At the same time, not social science studies, but legal overview studies we were looking at legislation. I did one of these studies. We were looking at legislation. We were looking at litigation to the extent that it was reported, where both federal and state municipal social service grants were being given out, and the kind of damage that was doing to religiously or faith-based social service providers. Essentially, and I'm overstating it just a little bit, but the government was strangling the spontaneity, the kind of the faith drive that gave rise to the particular social service outlet and motivation that created these little neighborhood storefronts of unconditional acceptance and grace. All right, so government, by strings attached to money, was becoming a relentless engine for secularization. All right, now I want to jump ahead to the second part of the 90s. One of the promises, you're too young to remember, but one of the promises that Bill Clinton made on the campaign trail was, we're going to change welfare as we know it. And indeed he did. He fulfilled that promise. And in August of 1996, he signed the Comprehensive Welfare Reform Act. And a small part of that was a provision which was dubbed with the moniker charitable choice. And that affected what was called TANF, or Temporary Assistance for Needy Families. And that was about, at the time, 1996, that was about $16.5 billion. Now, I know in the environment of the last couple of months, $1 billion doesn't mean anything to you. It has to be T with a trillion. But back in the late 90s, $1 billion was a lot of money, and $16.5 billion was a lot of money. And I'll come back momentarily to what charitable choice was, but just a year later, charitable choice provisions were put into what was called Welfare to Work, which is a program that no longer exists, has been phased out. But that was 1997. Then in 1998, charitable choice was put into the Community Services Block Grant Act, which is how the government funds community action agencies. And then 2 years later, in 2000, all of this during the Clinton years, charitable choice was put into something called SAMHSA, which is Substance Abuse and Mental Health Services Administration, which is part of HHS. All right, now, very briefly, what is charitable choice? Three things. I'm sort of being reductionist here. First, it was, and in no particular order, but first of the three things was that it was saying that faith-based organizations should be able to compete for federal social service grants on the same basis as non-religious social service providers. So we changed the question. The question was no longer, who are you, but can you do the job? If you can do the job within the parameters of the program, which is, of course, established by Congress, and then elaborated upon by the executive branch in regulations, then if you can do the job, you ought to be able to receive the grant. Now, of course, there was oversight, and there was acknowledgement. If you were a faith-based organization, you couldn't, of course, divert money to proselytizing, to religious instruction, to worship, to other inherently religious activities, and so on. And again, this was no promise of money. It was simply a promise of an equal opportunity to compete. Second thing that it was if you did take a federal social service grant, then you retained your religious character or autonomy. There was obviously some loss of autonomy, but the core of that character of what made you what you were was to be preserved, including what later became a major issue of contention, and that is that you could continue to staff with those of like-minded faith. And then the third thing was focused on the poor and needy themselves. Not only could they not be discriminated against on the basis of their faith, everybody had to be served, but if they qualified for assistance, then they, to the extent possible, and this was more possible in an urban setting than in a very rural area, but they were to be given a choice. So this is the choice in charitable choice. And the choice is if they might want to choose a faith-based provider. If one was available, one might not be available. But if one was available, they could choose a faith-based provider because for whatever reason, they may think that they're better serviced by a provider which aligned with their faith. And also, if they most emphatically did not want to receive services from a faith-based provider, then the government had to provide an alternative choice, so no one was being forced to receive services from a religious outlet. All right, so all that was dubbed kind of charitable choice, and now I want to jump ahead to 2001. Now, George W. Bush, president, early in his presidency, and he, of course, had experience with charitable choice as a governor, because TANF money is sent down to the states, and then the states actually deal with servicing people who are means tested and qualify for TANF. So he had, as governor, had experience with charitable choice, et cetera. And that was how he initially got interested in this idea. And then he pursued it on his own through like Mayor Goldsmith, who was mayor of Indianapolis at the time, and some other people. So he names this new White House office, the Office of Faith-Based and Community Initiatives. He names as the director a Democrat from Philadelphia, an Italian Catholic by the name of John DiIulio. DiIulio is fairly well known as an academic at UPenn. He had done work in juvenile delinquency and also had been a critic of the government and how it did social service through private sector providers, to be sure. And he was a very charismatic guy. And at the same time, 5 centers were created. One of those centers was over at the Department of Justice, and that's where I was during the introduction that was mentioned. So while Larry Thompson, the Deputy Attorney General, was de jure my boss, Don DiIulio was de facto my boss. So I got to work with DiIulio for about 7 months that he was director of the White House Office of Faith-Based and Community Initiatives. Over time, through executive orders, the 5 centers were increased to 11. So today there are 11 centers. And the marching orders were 3 things. DiIulio had input in 2 of the 3. The marching orders was, first of all, there'd been all this speculation that there are barriers out there to faith-based organizations competing equally or having an equal opportunity. So there was to be an audit done, and that audit was completed and rolled out at Brookings in July of 2001. And it was done by the 5 centers. We just audited the 5 departments. So Department of Justice was one of the departments that was audited. We don't think of justice as a social service outlet, but actually it's quite a lot of social services are done through the Department of Justice having to do with corrections and juvenile delinquency and things of that nature. All right, so we were to first of all find out, are there really barriers, and then if there are barriers, to remove those barriers to the extent that we can do so within the executive branch, because many of them were just long-standing customary practices. They weren't imposed by Congress. Of course, you couldn't remove the ones imposed by Congress because only Congress can remove those. Then the 2 ideas of the office that DiIulio had to major input on because of his academic background. One was accountability. And by accountability was, of course, any private sector, faith-based, or non-religious provider had to do periodic reports on, maybe you have a grant that goes over 2 years or 3 years, but you'd have to give 6-month or annual reports and so on. But what they would report was the number of people served. So let's say you were doing drug rehab, and they would simply report, well, we served 5,000 people in over a 15-month period. But what they would not do, or had not been required to do, was how many people did you really help? How many people actually got off drugs and stayed off drugs? And did you go back 3 years later, were they still off drugs? And 5 years later, were they still off drugs? In other words, were people really helped, and they weren't asked to report these things. It was just, well, we served these people, and so you gave us this money, and it's all justified. All right, so DiIulio said that's got to change, accountability. And then the third thing was he wanted to drive social services, because large social services had received, big providers had received a lion's share of the money because they had sort of learned the system. I don't mean they gamed the system, but they'd learned the system. Here's what you put in your grant application, and you're going to get your money, and et cetera, et cetera. And they would fund the same groups over and over and over and over again. And of course, the funders liked that because they were comfortable with these groups. And John said, we need to drive this money down to the neighborhood level. The little storefront groups that only have 2 or 3 employees and maybe a couple of dozen volunteers. Those are the people that have high credibility in their neighborhoods. They know the people, they live in the neighborhood quite often. They themselves, like if they're running an Alcoholic Anonymous program, they themselves were once an alcoholic. That's the kind of training. They didn't have fancy degrees in social work and things of that sort. But in many respects, they didn't qualify for federal grants because of a variety of reasons. Often because they didn't have the capital capacity, or their building didn't comply with the fire codes and things of that sort. And they didn't have the money to change that. All right. So that was addressed by something that came to be called the Compassion Capital Fund. All right, now I want to jump ahead to the Obama proposal, which of course President Obama rolled out the proposal at the National Prayer Breakfast on May 5th. It was leaked to the press the day before, so that because normally you don't send hard news reporters to the prayer breakfast, you maybe send a religious reporter, but it was leaked to the press on the 4th that the president was going to announce a hard news, he was going to lay out his faith-based initiative and name Joshua Dubois, Pentecostal minister, 26 years old, formerly with his campaign staff, formerly with his senatorial staff, as the new director. Now, none of this was much of a surprise because in July of '08, then candidate Obama had given a speech at Zanesville, Ohio, and he said, well, he said a number of things, but for our purposes, most salient is he said, I'm going to continue the office, but in altered form. And he knew that he would get criticism from his base for that because many in his base wanted to do away with the initiative. And so to blunt that criticism, he said, we need all hands on deck to do social services. We cannot afford as a country to cross anybody off the list. So we need all hands on deck. That was kind of a memorable phrase. The other thing he said was, but if you receive a federal social service grant, then you cannot employ on a religious basis. All right, that was back July '08, so here, February 5th, he rolls out the new office at the prayer breakfast. Obviously doesn't have time to do details, but he says, later today I'm going to sign an executive order, which he did, and also the White House press office came out with additional details. And of course, Joshua Dubois was ready at hand to give a number of interviews to the press, which he did, and that was quickly reported. So we actually know a fair amount. I don't want to overstate it as to what's going to happen, though there's a lot of question marks. All right, so what's the same and what's new? And now I'm going to hit these real quickly. What's the same? Well, there's only a cosmetic change in the name. The old name was Faith-Based and Community Initiatives. Community was this idea of driving it down to the small group in the neighborhood. Now it's the Office of Faith-Based and Neighborhood Partnerships. So it's neighborhoods, not community, but it all means the same thing. So we just have essentially a name change, which is entirely cosmetic. Second, the 11 centers are to be kept. Third, it was established by an executive order. Bush got a lot of criticism that it was, just, this thing was established by executive order, not by Congress, but President Obama established it by executive order, and there's been no hint whatsoever that the Obama administration intends to go to Congress to make this permanent through congressional legislation. That may happen, but I haven't heard anything about it. Fourth, informally, the old office would go to the Department of Justice for legal questions. That is now formalized, but it's really all the same. The new executive order says that Joshua Dubois is, if he has legal questions, those legal questions will go to the Department of Justice for answering. But that simply formalizes the old informal process that went on in the Bush years. Fifth and last, as to religious staffing rights, and this is very interesting, because this is a major bone of contention. He said nothing, the president said nothing about religious staffing rights. The executive order said nothing about religious staffing rights. The White House press office report said nothing about religious staffing rights. It said things about like, well, we're going to obey the Constitution, we're going to obey the Establishment Clause, we're going to obey separation of church and state. But of course, all of those things are up for grabs as to whether religious staffing rights violate or don't violate those particular provisions. And so pretty clearly, the president is trying to give himself, and then of course Joshua Dubois was hammered by the press, this is the big issue, is there religious staffing rights or not? And he said, well, that's just one of those many legal issues that we're going to take up case by case, and when we have a reason to take up that issue, and I'm given authority under the executive order, then to bounce that over to the Department of Justice, and we'll just get to it in time. Okay? And just so, just sit on it, folks. All right, so what does this mean, trying to read between the lines? Clearly, the president has stepped away from what he said in Zanesville in July of '08, because there he was quite clear. And now he's wanting maneuvering room. I mean, that is obvious, all right? That's not even reading between the lines. And it seems, this is a little pushing it a little bit, but it would seem like, well, you know, if religious staffing processes, if it's unconstitutional or otherwise illegal, then they could hardly let this unconstitutional or illegal act continue to go on. They'd need to stop it right now. So it seems to me that it's been downgraded from a constitutional or legal question really down to one of policy. And it appears to me that the president has bracketed this particular issue for himself as a policy issue, not a legal issue. I also think it's a policy question because I think it is legal. All right, now what's new? Two things are new. There's a council, advisory council, 25 people, 15 of them were named right away. None additional have been named. About half are religious leaders. There's a few essentially religious activists, registered lobbyists, and then there are some leaders of non-religious faith-based organizations. This is a formalized feedback loop, and that's probably a good thing. And but what this council is going to look like or be able to do is unclear. Dubois says that the council can do investigations, it can issue reports, it can form task forces to do this or that. They're going to be funded out of HHS. So there's going to be adequate funding for them to do quite a lot. On the other hand, these are all very, very busy people. So, the reservation would be, well, if they're really going to be active and issue reports after they do studies and so on, this is really going to be, the studies are going to have to be done pretty much by the staff. That would be people working for Joshua Dubois. And so is the council really going to reflect what the staff thinks? And, or will it really truly be an independent council that may tell the president, well, Mr. President, we like ABC, but we don't like XYZ? I just don't know. These are very busy people, and I can't see them having the time to really dig deep and do what else that they do. The second thing is the portfolio of the office is hugely expanded. Not only are they to continue faith-based, which would be more than enough of a handful. In addition, they're to work in the area of teenage pregnancy and reducing abortions. They're to work in the area of fatherless homes. And they're to work in the area of interfaith dialogue. And while they don't specifically single out interfaith dialogue with Muslims or moderate Muslims, one thinks that religious groups in America for a long time have informally been reaching out to moderate Muslims for interfaith dialogue and trying to reach common ground, some understanding, and encourage moderation within Islam. So each one of those 4 areas is just huge and could overwhelm the office. On the other hand, one press report, Dubois said that he would have a staff of 50, which would be huge because under Bush the staff was 8. So that's an increase of over 600%. So maybe with a staff of 50, you can handle all of these things. All right, let me break off there and pass the mic over to Chris.
Great, thank you, and thank you to all the sponsoring organizations for having both of us here. And for me personally, it was nice to to see Carl again, and the last that we had worked together was on this bill that became law by unanimous consent in both the House and Senate, the Religious Land Use and Institutionalized Persons Act. And I think one of the last conversations we had with each other was probably eight or 9 years ago, talking about whether it's going to be found to be constitutional or not. And so we were, it was nice to have the unanimous okay from the Supreme Court, at least up to this point, on that statute. And once again, I agree with a lot of, maybe not with the outcome of what Carl has said, but certainly a lot of his analysis of what's happened and kind of why things happened. I think from our perspective, I think that what happened 8 years ago with when Bush first headed down this road of the faith-based initiative was really kind of a paradigm shift in how religious organizations can, or at least could, if they wanted to, participate in federal programs. And up to that point, and really for decades, the paradigm was that religious organizations could participate if they at least basically follow the same rules that other participants in these social service programs follow. And there certainly are places where there was not complete uniformity in how those rules were followed, but the basic, basically there were organizations that are religiously affiliated organizations like Catholic Charities, Lutheran Social Services, United Jewish Fund, that have been longtime participants in government programs in some places. For example, of Catholic Charities, in many of their Catholic dioceses, Catholic Charities often get the majority of their funds from government sources, sometimes 70, 80, 90% of their funds. But what was kind of understood was that everybody plays by the same set of rules. And there may have been, and something that I think has happened since the Bush faith-based initiative began, was that people kind of came out of the woodwork with places where people weren't always quite all following the same set of rules. When you talk about the head of Catholic Charities often would only, actually I think always is a Catholic, but the people who are actually involved in these programs would be people that were able to do the work, and regardless of their religion. And but I think that and it's kind of our assessment of kind of what a big part of the motivation for this paradigm shift came from a lot of times, I think, from the shift in the many smaller non-denominational churches that didn't have these, and sometimes they're very large individually churches, but not denominational churches. They don't have many churches don't have anything comparable to Catholic Charities or to a Lutheran Social Services, but are out doing social service work and doing it oftentimes without state or local money, doing it without federal funds, doing it out of their church basement or social hall, as opposed to having their own building dedicated to provide these kinds of services. And so I think our assessment was that the push for this really came from a lot of churches and houses of worship that were involved in doing this social service work, and we're seeing other churches that were getting these federal funds to do the work, but they were these kind of big operations, and sometimes very big operations, but that when they had a program with 2 or 3 people involved in it, that they weren't able to compete for those funds and those grants. And one of the things that we worked with several members of Congress on soon after the Bush administration started was looking at other ways to bring other kind of smaller social service organizations, religious or non-religious, into the process of applying for grants and being able to carry out social service grants. And that there's certainly, for lots of different reasons, there are reasons to bring other people into the process. And for religious organizations, though, that means in most cases setting up a separate organization to do that, which doesn't cost a whole lot of money, but it does require a commitment to doing that. And then finding other ways to basically segregate out those activities from the activities that the church or the house of worship does in the rest of its life. And then with that separate organization can then operate by a different set of rules than the rest of the church has to. And one of the things, we work a lot with a group of moderate Baptist churches, the Baptist Joint Committee, and one of the things the Baptist Joint Committee spends a lot of time talking to their churches about, their congregations about, when they are considering applying for government funds, is basically to make a decision of, what kinds of things do you as a church want to do in terms of social services, where you think it's important that the services be done with a religious content, that the services be done by people who share the same faith, and that those things should be funded with your own funds. But where you're motivated as a church to provide social services, but you feel that there's not a reason that they be done with a specific religious content, or that everyone has to share the same faith in either providing or receiving social services, then you set up a separate organization to do that and to comply with the same set of rules that everybody else plays by. And really what the Bush Faith-Based Initiative was setting up a separate set of rules for religious organizations only, and setting up a separate set of rules that with the mindset that the money could go directly to the church, that there did not have to, or other house of worship, and there did not have to be this segregation of activities. And certainly that's one of the reasons why this hiring issue that really has become the flashpoint in the whole debate for 8 years now gained such primacy for both sides, is because on the one side you have religious organizations they're talking about the church itself receiving funds, not a separate Catholic Charities kind of thing, but the church itself receiving funds. Then there's a lot more concern about making sure that the church has the autonomy to hire whoever they want to hire to provide those services. When if it was a separate organization, there wouldn't be quite that same level of motivation. At the same time, kind of on the other side, the groups that I spend most of my time working with have a big interest in enforcing these civil rights laws kind of across the board. And interestingly, one of the first, kind of the kickoff to the modern civil rights movement was actually in 1941. President Roosevelt integrated the shipyards. And in the process of integrating the shipyards, what he did to integrate the shipyards is he wrote an executive order, and it basically said, initially it was defense contracts, that in these defense contracts you couldn't discriminate based on race, national origin, or religion. And then kind of over time, and that was really the very first of the kind of modern civil rights movement. That was really the very first win, and it had a big impact because the federal government, of course, is a big employer itself, but also is a big provider of employment through federal contracts. And then that got expanded. That eventually got expanded out to include additional categories. So things like disability and sex and other things got added over time to that executive order, similar executive orders, and then it also expanded out to cover more programs. So eventually it covered almost all federal contracts. And then similar rules were set up for lots of the grant programs, and in some places Congress set up its own set of rules for non-discrimination in these programs. And the idea through this, through the 60-some year period has been that when you're participating in federal programs, either as a grantee or as a contractor, that some special obligations attach. And nobody's saying you have to take the money of these federal funds, but if you decide that you do, there come some special obligations. And we hope that there are obligations that, as Carl talked about, we hope that they're not obligations that stifle innovation and do all those kinds of things. But they are obligations that are important. And one of those obligations certainly is that everyone should feel welcome into the program. Everyone should feel that it's a program that doesn't discriminate against them as a participant. And that when you're talking about federal dollars, federal taxpayer dollars, that nobody should be discriminated against in working in those programs. And certainly one of the kind of illogical things that I've kind of always puzzled over that has been this idea that if what you are offering and what you are providing is a high level of social services as a social service provider, you want to receive federal funds and participate in a federal program, you're saying that you're going to do this without putting any religious content, which is really standard. You're not going to proselytize people in these programs. You're not going to provide religious instruction to people. You're not going to require people to be part of a religious worship service. You're not going to be infusing religious content into the federal social service program. Then why is it so important, and why do you need people who share your particular faith, and sometimes even within your faith, why do you have to have people that share particular tenets of your faith in order to be in this federal program? And so that, but this hiring issue has been the big tension and the big fight kind of throughout the Bush faith-based initiative. I think I agree with Carl's assessment and kind of analysis of the Obama faith-based initiative, and certainly has been a disappointment up to this point because there hasn't been a challenge to this paradigm shift. And it did sound last summer when then candidate Obama announced his program, it did sound like there was going to be a shift back to, we want you to participate. We're going to make it easier for you to participate, but you also have to comply and abide by the same set of rules that everybody else complies with. And it also seemed that his, and I think, if you could read anything into the name change, which is really, I think, the only significant thing that's been done by Obama, is to change it from faith-based and community initiative to faith-based and neighborhood partnerships. I think his idea is really to bring, as I understand it, what he was looking to do a better job of is to bring smaller social service providers of all types into participating in these programs, which probably for the country would be a good thing to bring more providers in and people that are closer to the neighborhoods. But there's been a I think it's hard. I think it's a hard dynamic to change when you have 8 years of kind of things heading in the in a different direction to switch that. I think that Obama made his job politically much more difficult by creating this council as well, because what he did by doing this, which I think it's I do think it's odd in that for how much criticism President Bush came under for his faith-based office, Bush never went to, and certainly every president has consulted and should consult religious leaders along with all kinds of other leaders in this country. But Bush never created anything like this Council of Faith-Based and Community Leaders, which is mostly faith-based leaders and very few community leaders that are not faith-based in it. And it really is it's kind of I don't think it's necessarily an unconstitutional road to head down to have this kind of council, but it certainly seems like a bad idea for lots of different reasons. Because one of the dynamics I can tell you, because I've seen it, kind of on the progressive and moderate end of the religious community, is that there's been all this jockeying to get onto the council, that everyone's looking for the presidential stamp of approval, as you're one of the you're going to be one of the 25 select people on this commission and or committee, and 15 have been named so far. I've heard that 9 are about to be named of additional people. But what it does require is it did require the president to pick and choose among his supporters, among his opponents, among different religious groups, and there are tensions. As good as the interfaith dialogue often is among different religious groups, there are tensions, and there are people who will not go on. There are entire communities that will not go on even a coalition letter if certain other groups are on, and that's something that President Obama and the Obama White House has had to deal with, and there is something that even if it's not unconstitutional harm, there is something wrong about having a presidential selected group of religious leaders, even if they are from a right-left spectrum, which this council has. But now that he's kind of created it, he's also created very public and high-profile. He's selected some very high-profile people who are there, who now have the ability to threaten to quit and to go to get their story on the front pages of the New York Times or Washington Post or wherever, if President Obama veers off of wherever they want it to go, whether it's in a direction that the ACLU likes or a direction the Christian Legal Society likes. He's kind of got this dynamic that has really could really mire things down in action. Just a couple things to I think look for over the next couple months over the coming year. One is this case-by-case approach and what that means. The way, as Carl said, the way that the Obama White House has dealt with the question of these hiring issues, but there are other issues. The hiring is only the one that gets the most attention, but there are other issues out there of these places where religious groups have kind of their own set of rules, have gotten their own set of rules over the past 8 years, and he just kind of punted it in the executive order over to the Attorney General. And then it was explained as well, the Attorney General is going to decide these things on a case-by-case approach. And there seems to be kind of something fundamentally unfair and troubling about having a case-by-case approach when you're talking about religious organizations or any organizations participating in federal programs. And it really what should be done is it should be, the Bush administration, to its credit, even though we didn't like the rules they came up with, they have a set of rules. It's a clear set of rules. There's one set of rules, and it applied. Those rules eventually were applied in all the agencies that provide social service programs, and there are one set of rules for religious participants in these programs. Our view is there should be one set of rules for all participants, but at minimum you ought to have one set of rules that applies to the religious participants. And if you go to a case-by-case approach, you do open up the chance that different groups are going to be treated differently, and who it is who's making the complaint about being excluded from a program and that prompts a case-by-case review is going to, who they are is going to affect how that case is going to be decided. And it seems like a better position, certainly what we've urged the Obama administration to do, is to have a review and for the Obama administration to make the decision on what it is that they're going to apply, but apply that as a single rule. And if they decide, which we would hope that they don't, that there is going to be a single rule dealing with religious organizations, then, kind of so be it. But that's certainly a better approach than saying, we're just going to decide these as they come up. And the other, just one last thing, I think, the kind of, I think the other thing to watch out for in terms of, in addition to kind of the hiring, what decision the Obama administration eventually makes on the hiring issue is that there are actually two OLC opinions from the Office of Legal Counsel, which is part of the Justice Department. There are two opinions that were put out during, I think, the second term of the Bush administration that are both pretty significant opinions, and we want to see whether we've urged that both of them be withdrawn. One deals with religious hiring rights, and it basically takes for everyone here, and I assume everyone's taken constitutional law by now, but the Religious Freedom Restoration Act, which in City of Bernie, as you know, is invalidated as to its application to state and local governments. The federal government still takes a position that the Religious Freedom Restoration Act is still good law, and as to the federal government itself, and does not dispute its application constitutionally to the federal government. And what the Office of Legal Counsel did a couple years ago was it decided that any place where there's a federal civil rights protection that prohibits religious discrimination in hiring in any federal program based on protection against religious discrimination, that the Religious Freedom Restoration Act essentially provides an exemption for religious groups. And the idea is basically that these religious non-discrimination statutory provisions cause a substantial burden on the religious exercise of the religious organization seeking a federal grant, and that the government does not have a compelling governmental interest in enforcing those civil rights provisions as to the religious organizations. And I think the analysis is mostly that because the prohibition is not in every statute and not throughout the U.S. Code, the government's interest can't be compelling. And it's something that's certainly seems very at odds with both how the Religious Freedom Restoration Act has been applied up to this point historically, but also seems to be very much at odds with how the courts have generally viewed prohibitions against religious discrimination and other civil rights laws, as well as civil rights protections generally. The other OLC opinion deals, and very briefly just deals with a very old, 1971 or 1972 Supreme Court case that essentially says that the government can't finance any part of a building it can't fund any building for any purpose that's going to end up being used for religious purposes. So in other words, at a religious university, and I think the case arose at a Jesuit university, the government can fund buildings that are used as law schools, as chemistry buildings, and other places, but they can't fund buildings that are going to be used for religious purposes, and that protection or prohibition against using those buildings for religious purposes applies in perpetuity. And that what the Office of Legal Counsel did is, I think they kind of predicted out to the future of, would a future Supreme Court, would this Supreme Court deciding a similar case now come out with a different result. And so the Office of Legal Counsel opinion essentially lowered that that barrier against funding the bricks and mortar of religious organizations. And that's been kind of carried out in several different regulations, most notably in regulations put out by HUD dealing with various housing programs. And it is, I mean, it's a problem in lots of different reasons, but even with the Office of Legal Counsel, it's a problem because their role, which, you know, obviously they've veered off from the torture and detention area, lots of other areas, but their role is really to interpret the law as it is and not to guess at what a future Supreme Court or this Supreme Court would do if it got a case. And here's a place where you actually have a case that is precedent, it's been precedent for a long time standing, and they basically said the federal government doesn't have to comply with that. So those are two opinions two OLC opinions to kind of watch out for, and, you know, kind of at minimum, those I think are two areas where we'd like to see those opinions withdrawn. I think I'll leave it at that, unless Carl, you have something you want to respond to.
Probably got time for maybe one or two questions. I don't know if anybody in the audience has any questions that they'd like to ask.
I remember when DiIulio left, you kind of glossed over, I think, why and the circumstances under which he left, and he gave the article in Esquire to Ron Suskind, and it was pretty damning towards the people who were kind of operating and setting up the office initially. And I'm wondering if you could comment on how Obama is going to make, or if it's even been put out, what types of changes will be made in terms of granting federal funds, who's going to be reviewing these applications, and how that will change.
The the Esquire magazine piece by John DiIulio, he later apologized for what that's worth. But it wasn't criticism of those people in his office or in there were 5 senators at the time. It was criticism of the people above him in the West Wing. And I think he had a wonderful phrase, something like Mayberry, Machiavelli, and so on. But it was people above him, not his cohorts or others. But to the substance of your question, I think they're going to take their cues from what the Supreme Court has permitted under the Establishment Clause. And the idea that direct funding can go to religious groups is not an altogether new one. Agostini in 1997, Mitchell versus Helms 2000, cases that hopefully you've touched on in your church and state review, if you have time for it in your overview constitutional law, has said that when direct funding goes to religious groups, there is a different set of rules required by the Establishment Clause. It's not that the funds can't go, and those happen to be schools, K through 12 schools, include our parochial schools, religious schools, whatever you want to call them. But there needed to be separation by time or location to make sure that the government funds were not diverted to explicitly religious purposes. So the regulations that came out concerning social services then just simply followed that kind of case law. While that is a different set of rules, you know, the government could fund, if it wanted to, constitutionally, directly fund the Sierra Club. It could directly fund Planned Parenthood, but it can't directly fund the Methodist Church or the Assemblies of God Church. And the reason it can't do that requires a different set of rules, all driven by the Establishment Clause. So I think that those kinds of parameters are given, and whoever's doing the reviewing now under the new presidency is going to have the same sort of restrictions. And that's why, to build on something that Chris was saying, this peculiar case-by-case thing, as lawyers, when I first heard that case-by-case stuff, that didn't make any sense, because as lawyers, we're thinking issue by issue. If we're talking questions of law It's issue by issue, and once the Department of Justice decides a legal issue, then that's the answer, not only for the grantee in front of them, but for all other grantees. That's the answer. It's not case by case. We're not going to have a situation where grantee A, Salvation Army, we get one legal answer, and grantee B, World Vision or Catholic Social Services, we get a different legal answer. It just doesn't make any sense. And the only way I can make sense of that is to say that this has been downgraded from a legal question to a policy question. And the president has bracketed off the policy question, and he's going to make that call. And he knows that no matter how that call is made, he's going to make some people very, very unhappy. And so he's bought himself some time to make that call.
My memory of the Giulio article, and I just remember he did take it back or apologized or whatever for parts of it. But I think it's also a frustration a lot of other people have had with the Bush faith-based initiative, and maybe they'll end up having the same with the Obama faith-based initiative, was that I think a lot of the people that came into it, their expectation was that this was going to be a commitment to finding new ways of serving poor people, and serving underserved communities, and what ended up happening was that it ended up being focused much more on, and certainly the debate ended up focusing mostly on trying to figure out how to get money to remove legal restrictions from being able to put money into churches directly to provide these social services. And one of the things that was really interesting that we did about a year into the Bush administration is that all the one of the things that agencies were directed to do by President Bush was to find barriers to participation by social service programs and religious social service programs in programs run by their agency. HUD, the Department of Housing and Urban Development, was the only agency that actually did a full kind of open comment period through the Federal Register, the kind of way that they would make a rule or anything else. So there was this Federal Register notice that actually ran twice looking for comments. They got, I can't remember the number, but it was like 150, 200 comments mostly from religious social service providers around the country. There was exactly one social service provider asking what the barriers were that they were seeing in their work. There was exactly one social service provider that raised the religious hiring issue as a barrier. There were several that wrote in opposing, and we weren't running any, and as far as I know, I don't think anyone kind of on our side of the question was running any kind of campaign to get people to write in. Some of them wrote in basically saying that they were upset that there were organizations that weren't following the same civil rights laws. But what almost everyone wrote in about were the same kinds of things that probably every social service provider out there would write in about kind of the bureaucratic red tape that they're coming across, the barriers to getting in, the favoritism that applies in these grant programs and everything else. And that was really, and I think for a lot of the organizations, if you go back, you look at those comments, what these organizations really wanted help with was navigating their way through the morass of the grant-making process. And instead what was offered to them was, well, here you have a right to discriminate. And then, by the way, we're also cutting the funds to all the programs that you want to be in. So the pie has actually gotten smaller in these programs. And, I think our hope with the Obama administration, I think this is kind of what he's been selling, is that he'll make it easier for everybody to get access to these programs by making these programs more accessible to smaller social service providers, and that he'll also increase the pie so there's more organizations that can participate in a bigger social service program serving more people. But so far that doesn't seem to be the direction he's headed in. It seems to be kind of more fiddling around with this council. But I think for a lot of people who not necessarily ACLU people, but people that do provide these direct social services. I think the frustration was that, you know, it was just rearranging the legal structure and not actually providing any money, and in fact, there being less money to provide these programs.
Well, unfortunately, we're out of time. Federal court's meeting in here in 5 minutes, but let's take another opportunity to thank our